Hello and welcome everybody. I'm Sana Parvez, your legal expert for Hitbullseye. In today's topic, we are going to cover law on passive euthanasia and living wills with respect to the recent judgment of Common Cause versus Union of India. Ernest Hemingway once stated that a man can be destroyed, but he cannot be defeated. When Justice D.Y. Chandrachud translated it into Indian context of Article 21 of the Constitution of India, he stated that wherever there is a situation of dignity or living without dignity, a man would choose to end his life with dignity rather than to live a life of non-dignity. So, in the light of the same, today we shall be discussing the right to life versus the right to die and under what cases is what allowed. So, first of all, if we consider the right to life in India, uh, we will uh, we will basically first of all discuss, can one choose life or death as per his own wills or volitions. So this there are two landmark cases in this regard. First case where it was discussed extensively was with regards to the constitutionality of section 309 of the Indian Penal Code, and this was first discussed in P Rathiram versus the Union of India. Here, Section 309, which is attempt to commit suicide, was considered by the Supreme Court as to whether section is constitutionally valid or not, and more so if it is constitutionally in consonance with Article 21, that is right to life. Article 21 of the Constitution states that every person, no person shall be deprived of right to life and personal liberty, and but it is subjected to except by the procedure established by law. So here, in P. Rathiram case, the Supreme Court stated that it is constitutionally, basically, right to die is constitutionally upheld, and it basically struck down Section 309 of IPC as being violative of Article 21. It essentially stated that when a person is choosing to die anyway, when a person is trying to attempt to commit suicide and a person fails, the successful scenario would have been that if a person is trying to commit suicide, that he would have actually ended up doing suicide, and then the question of penalty would have not arisen, of course. But however, in the case if he fails, then firstly he has to go on living his life, and secondly he is inflicted with further punishment. So in this case, it kind of becomes very cruel because it becomes a sort of a double punishment for this person. So here, the court stated that it was constitutionally invalid. However, further, in Gyan versus State of Punjab, this judgment of P. Rathiram was overruled, and the Supreme Court stated essentially that the right to die is not included in the right to life. It does not come with the right to life, because right to life is something that has gained the value of sanctity as per the morals and the ethics in India. So first of all, every person is not only the owner of himself, but he is also a subject of the state or resource to the state. So he cannot choose to die himself firstly, and he cannot choose to cut his life short by unnatural means. And not only that, it is also creating panic in the society. Therefore, Section 309 would be continued to be an offense. In this regard, further, there was a report by the Law Commission, that was the 196 report on medical treatment of terminally ill patient, protection of patients and medical practitioner, and these guidelines came in 2006. Under the guidelines, the Law Commission gave certain recommendations or guidelines. So as to the fact that a law should be made about the terminally ill patients. First of all, our Section 309 should not be constitutionally, should not be essentially an offense. And if somebody is trying to commit suicide, then he should be sent to some kind of a treatment facility and not to jail. And the second definition was that something should be done with respect to terminally ill patients. So with respect to terminally ill patients, this thing was a hot topic, very hotly contested or discussed topic at this point of time around 2006, and the reason was the Aruna Schomburg case. The Aruna Schomburg case was finally decided in 2011, but it had been going on in discussions. And the facts of the case essentially were that there was a woman who was a nurse in a hospital in Mumbai, and she was one day she was attacked by the janitor, and the perpetrator of the crime rendered her in such a position that she was rendered into a permanently vegetative state, and she continued to be in that state for the next 36 years of her life. So she was in a coma, she was incapable of doing anything, she was incapable of speaking, probably perceiving, or any activity. The food was administered to her through food pipe and everything, and she was basically on fully on the support of the machines, and the hospital was taking care of Aruna Schomburg. Here, a petition was put in the Supreme Court to request passive euthanasia, and passive euthanasia for the first time was discussed in the Indian courts. So, here, first of all, if we understand what is euthanasia literally it's a combination of two Greek words, and it means good death. So essentially, good death when a person actually has a desire to die, or the life is worse than a condition of death in that person's case. So here, the contentions which were brought against the euthanasia, essentially the hospital staff was against euthanizing the victim or the person who was in the permanently vegetative state. The contentions by the doctors were that it is immoral, inhuman, and it is prone to abuse. Immoral, inhuman in the sense that it is not only immoral, but the doctors also considered the fact that at the time of at the time of becoming doctors, they are required to take a Hippocrates oath. So the oath requires them to safeguard the life of the people, of the patients, to the last breath of the patient's life. So essentially, going against this oath would be morally, not only morally, but against their Hippocratic oath. And secondly, it was discussed that if passive euthanasia is allowed, tomorrow it can be this law can be essentially abused, and people who want a certain person dead can cause the death of that one person. Then, in this case, finally, the Supreme Court drew the distinction between passive euthanasia and active euthanasia. In active euthanasia, or it is also called aggressive euthanasia, in this, somebody is actually actively doing something, or the doctors are actively doing something, administering something, an injection, a lethal injection, or anything of that sort, in order to take the life of that person. And in passive euthanasia, they're simply withdrawing the life support. So the contention, so basically the verdict of the Supreme Court was that it is the modern technology that has made us capable, that a person who would have otherwise not lived is living, and for many years, as long as 36 years and even longer, a person can live, even though without those machines he could have been he would have, under all probabilities, died. Now here, if the life is if the quality of life is very bad, then the court can also allow passive euthanasia, that is, withdrawal of this kind of treatment. In India, active euthanasia is a straight off infringement of Section 302 or 304, that is basically causing someone's death actively. However, passive euthanasia was allowed in this case under proper guidelines only. Uh, then came the case of Common Cause versus Union of India. Common Cause, being an NGO, filed a case which was finally decided in 2018, stating that a person also has a right to die with dignity. So essentially, they stated that when a person's right to life under Article 21 of the Constitution does not mean just right to animal existence; it means right to life with dignity. Here, the court said the issues that were in front of the court were whether right to die comes under the ambit of Article 21 of Indian Constitution, which guarantees the right to life. Is statutory legislation required to legalize euthanasia, or can it be done under the Supreme Court guidelines only? And is passive euthanasia separate from active euthanasia? This also we have discussed in the Aruna Shambhav case. And can legal advance directives regarding medical treatment be issued to a person who is incompetent to survive in the near future? Here, in this case, the court essentially firstly stated that it had already allowed, it reiterated that it had allowed passive euthanasia. Then, secondly, for the first time, it brought in the concept of living will or advanced medical directives. Basically, these directives are directions, or these directives show the will of the person. They're a declaration of the will of a certain person, that if in case in future he or she uh, basically is in a position that he or she is terminally ill firstly, and further incapacitated from taking any active decision, then it is an advance directive from that person that in that case the doctor shall be required to end the life or exercise passive euthanasia of that person if the person would want to die in this situation. So, here, the common cause, the organization basically prayed to the court to issue directions to the union government to allow terminally ill patients to execute living will, and if in alternative it is not allowed, in alternative the union government fails to give such directives, then for the time being, at least the Supreme Court should give out certain guidelines. And in the pursuance of the same, the Supreme Court had given out certain guidelines in 2018. However, recently, another Common Cause of India approached. I'm so sorry. Common Cause of India approached the Supreme Court again very recently, and Common Cause stated that the guidelines that were eventually given in Common Cause versus Union of India back in 2018 were not workable. So much so that the legal counsel for Common Cause, Mr. Prashant Bhushan, stated that in the last 5 years, there has from 2018 to this date, there has not been a single case where a living will has actually been executed successfully, because there are so many complications. It is essentially not a workable piece of guideline. So there were certain changes that were issued by, again, a constitutional bench which was led by Justice Joseph. So Justices K.M. Joseph, Justice Ajay Rastogi, Justice Anirudh Bose, Rishikesh Roy, and C.T. Ravikumar. This bench has not given certain guidelines. It has essentially altered the guidelines that previously existed from 2018. Let us have a look at the guidelines. Firstly, earlier only one guardian or nominee of the person, so executor is the one is executing the living will, and the person who would want to die in the future in case he is rendered terminally ill and incapacitated. So he was earlier required to file one nominee or one guardian who would take this decision on his behalf, and who would be involved in all the proceedings in case that the executor is incapacitated. However, here multiple numbers, earlier only one person was allowed to be acting as a guardian or a close friend. Here now More than one people can also be nominated as such. Second point of difference or second amendment is, earlier this living will was required to go to the JMIC, that is the Judicial Magistrate of First Class. He was required to ascertain whether the person was he was required to ascertain, or he was required to satisfy himself whether the executor was executing the will in under his own will and volition and with free consent. Here this requirement has been done away with, and it is sufficient for an advanced directive to be attested before a notary or a registered or a gazetted officer. So no requirement of JMIC is there as such. Then the judicial magistrate was required to forward a copy of the document to the registry of the jurisdictional district court, which would have retained the document in the original form. Here, of course, if the document is not going to the JMIC in the first place, then it is not required to go further through the JMIC any place else as well. In the next point of difference, the judicial magistrate was required to inform the immediate family members of the executor and the family physician if there was any. However, this requirement has been done away with, and now the executor himself is under the duty to inform his family and friends about the living will that he has executed. Then a copy of the advance directive had to be handed over to the competent official of the local government. The aforesaid authorities would then nominate an official as the custodian. Here, in addition to, you are still required to file it with the local government, file the legal living will with the local government. However, you can also put it in your digital health records. Next, to ascertain its authenticity, when the executor became actually terminally ill with no hope of recovery, the treating physician had to execute the advanced legal directive after ascertaining its genuineness and authenticity from the judicial magistrate. Here, in the new guidelines, it is only to be forwarded to the judicial magistrate. No authenticity check is as such required. In the next case, essentially in the next case, in earlier there were two medical boards which were required to be formed, and the medical boards and their eligibility criteria was set at a very high bar. Now the bar has been lowered a bit. Let us see what the bar is. In the first case, first medical board or the medical board which is taking the preliminary inquiry, that consisted of uh, the head of the department and at least 3 experts from the fields of general medicine, cardiology, neurology, nephrology, uh, psychiatry, oncology, with experience on critical care with overall standing of medical profession of about 20 years. Remember, this is very difficult to attain because it might be this kind of expertise might be available in some places but might not even be available in certain jurisdictions. After that, the decision had to be informed to the collector, who would make another medical board. This is the second medical board of the chief district medical officer, 3 experts again from the fields of general medicine, cardiology, neurology, nephrology, psychiatry, or oncology, with experience in critical care. And again, the experience would be required to be at least 20 years. Now, in the new guidelines, the preliminary inquiry committee that is to be set up has to have a speciality of not 5 years or more, and they're required to give this decision within 48 hours of the constitution of the committee. So it is a speedier exercise. And secondly, again, even in the second committee, which is the committee which is headed by the chief district officer, even then the requirement is 5 years of practice or 5 years of expertise, and they are also required to give their decision within 48 hours of the constitution of the committee. Next, withdrawal of treatment. The chief district officer, chief district officer was the chairman of the board, which was the board of the final approval. Will convey the final decision to the magistrate, who shall visit the executor and see, examine the executor, and what circumstances and what circumstances and what condition the executor is laying in. Here, only conveying of such decision would suffice. In the last point of difference, refusal by medical board, the hospital was required to ask the medical board as to how to go about it further. Now, even the family or anybody, the nominees of the executor, can request the hospital to refer the case to the secondary medical board if they do not allow the directions of the living will to be executed. So this was the recent judgment, Common Cause versus Union of India, of January 2023. I hope you all liked the video and understood the video. If you have any doubts, please you can ask the doubts in the comments, and have a good day. We'll be back with more topics in the next week.